Our next invited testifier is Kendall Seal, Vice President of Policy at the Center for Rights of the Abused Children. Mr. Seal, can you hear us?
Yes, I can.
All right, if you just want to place yourself on the record, you're coming in loud and clear, and you may begin your testimony when you're ready.
Certainly. Thank you so much, Chair, committee members. Good afternoon. As was mentioned, Kendall Seal, Vice President of Policy for the Center for the Rights of Abused Children. We work all across America with child welfare agencies, stakeholders, and policymakers with a mission focused on a future for every abused and neglected child to have a safe and loving home. To ensure children are protected and have the best chance for stability and a family connection, children should be quickly settled into a relative or foster home on the path to permanency. Children who live with family right away fare particularly well. That's why we support efforts to find relatives as soon as the child enters care, or as previously suggested, even before they enter care, to ensure the child's best interests are always at the center of placement and permanency decisions. So there's a problem. Currently, Alaska law requires the department to search for adult family members or family friends and prioritize his placement with a relative, which generally we support, of course, placing them with a relative. However, the parameters of what constitutes that due diligence search are not adequately defined in state law. State law does not detail what a notification shall entail, require timely responses, detail what must be reported to the court, or provide sufficient accountability for executing diligent search. Together, these structural issues result in avoidable disruptions when a child's relatives are not found upon a child's removal from their home, but appear months or even years down the line. This diminishes a child's stability and safety. Consider the following. Alaska. 20% of Alaska youth have 3 or more placements. The national percent there is 16%. The median number of months a child spends in care in Alaska, 22. The national number, 18. Finally, 13% of children re-enter care after a year of a prior incident. National, 11.5. Such instability fuels negative outcomes, such as going missing or subsequent risks for exploitation, even human trafficking. These are results the state must face and own. Through our work at a pro bono legal clinic that we have here, we know firsthand the harms children suffer when agencies and courts shuffle them from home to home in simple obedience to preferential lists, as opposed to the child's best interests, always guiding decisions. Too often, agencies are not incentivized to find the best relative placement at the start of the case and opt to remove children from the only loving foster family they may have ever known and send them to relatives they have never met. This solution, proposed in Senate Bill 181, promotes safety and stability in all the ways that was itemized in the previous description. A child's needs must always be paramount. This means finding relatives quickly, and if this cannot be accomplished, it means prioritizing stability and limiting trauma to the child through lasting and loving foster homes. You heard previously testimony related to the developing body of research showing and speaking to placement stability and the value of immediate placement with relatives. By passing this reform, children entering the foster care system will have a stronger pathway to being placed with relatives quickly. I want to address kind of straightforward some of the issues I noticed both in the fiscal note, but also in some other written testimony that was provided. Notably, I want to address the fiscal note issue. It was suggested that this bill might somehow delay permanency. I think the exact opposite is true. I just shared with you the results of what's currently in place, and that's failing Alaska's youth. This seeks to correct that. Second of all, there's a suggestion that there's an increase in litigation. Finding kids' family, finding them relatives, reduces litigation. It gets them out of the system faster. It's the exact opposite of what was suggested in the fiscal note. Think about the numbers. Alaska youth entering care, 2,500, 3,000. I picked Missouri, another state we work in. 12 to 13,000 entering care. Missouri, they said they only need maybe one full-time employee to address this concern. If those numbers are consistent, Alaska only needs 0.2% of a full-time employee. So I just feel like the numbers in the fiscal note aren't adding up. Second of all, there's some things I would just highlight in the language that the center would just elevate to the committee's awareness. In section 2, we would actually remove the age altogether, and suggest that a 9-month period that a child is in a foster home for 9 months would be enough. There's no need to make it a full year. The other thing we might suggest in section 4, you could create a floor of databases the state must consider, not a maximum, but create a floor of specific databases the state must check. Also in section 4, you could create a notice period where, for example, family members are provided they have 30 days to respond and express their interest, and that search could go over a 6-month period. So it's defined, and there's clear expectations about how long people have to respond. Those are the main remarks I want to make regarding this bill. I think it's a strong bill. I think it's the trend line in the states to seeing attention to defining diligent search, and I really want to applaud the sponsor for their leadership and sensitivity to this issue. Thank you.
Thank you, Mr. Seal. Are there questions for the testifier at this time from the committee members? Seeing none, just want to say thank you for being available.
Certainly.